Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Smith v. Arizona. In this case, the court considered this issue. Does the Confrontation Clause of the Sixth Amendment permit the prosecution in a criminal trial to present testimony by a substitute expert conveying the testimonial statements of a non-testifying forensic analyst? The case was decided on June 21, 2024. The Supreme Court held that when an expert conveys an absent lab analyst's statements in support of the expert's opinion, and the statements provide that support only if true, then the statements come into evidence for their truth, and thus implicate the Sixth Amendment's Confrontation Clause. Justice Elena Kagan authored the majority opinion of the court. The Confrontation Clause applies to testimonial hearsay, that is, out-of-court statements introduced for their truth. The key question is whether the non-testifying analyst's lab statements were introduced for their truth or for another purpose. The court rejected Arizona's argument that the statements were only used to show the basis of the non-testifying expert opinion, not for their truth. Evidentiary rules do not control whether a statement is admitted for its truth. This is a constitutional question. When an expert conveys out-of-court statements to support their opinion, and those statements only support the opinion if true, then the statements have been offered for their truth. The jury cannot evaluate the expert's credibility without assessing the truth of the underlying statements. In this case, the expert's testimony relied entirely on accepting the non-testifying analyst's statements as true. His opinions were predicated on the truth of what the analyst reported about her lab work. Allowing this practice would undermine previous decisions in Melendez-Diaz and Bullcoming and allow easy evasion of the Confrontation Clause. Therefore, the non-testifying analyst's statements were introduced for their truth, violating Smith's confrontation rights if the statements were testimonial. The court remanded for determination of whether the statements were testimonial by looking at each statement's primary purpose. Justices Clarence Thomas and Neil Gorsuch did not join the court's analysis of when a statement is testimonial, and each wrote separately to explain how they differed. Justice Samuel Alito authored an opinion concurring in the judgment in which Chief Justice John Roberts joined, arguing that the majority unnecessarily complicated the matter and should have found that the testimony sought to prove the truth of the statements and was, therefore, inadmissible hearsay subject to the Confrontation Clause. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kagan delivered the opinion of the court. The Sixth Amendment's Confrontation Clause guarantees a criminal defendant the right to confront the witnesses against him. The clause bars the admission at trial of testimonial statements of an absent witness unless she is unavailable to testify, and the defendant has had a prior opportunity to cross-examine her, and that prohibition applies in full to forensic evidence. So a prosecutor cannot introduce an absent laboratory analyst's testimonial out-of-court statements to prove the results of forensic testing. The question presented here concerns the application of those principles to a case in which an expert witness restates an absent lab analyst's factual assertions to support his own opinion testimony. This court has held that the Confrontation Clause's requirements apply only when the prosecution uses out-of-court statements for the truth of the matter asserted. Some state courts, including the court below, have held that this condition is not met when an expert recites another analyst's statements as the basis for his opinion. Today, we reject that view. When an expert conveys an absent analyst's statements in support of his opinion, and the statements provide that support only if true, then the statements come into evidence for their truth. As this dispute illustrates, that will generally be the case when an expert relays an absent lab analyst's statements as part of offering his opinion. And if those statements are testimonial too, an issue we briefly address but do not resolve as to this case, the Confrontation Clause will bar their admission. The Confrontation Clause provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. In operation, the clause protects a defendant's right of cross-examination by limiting the prosecution's ability to introduce statements made by people not in the courtroom. For a time, this court held that the clause's preference for face-to-face confrontation could give way if a court found that an out-of-court statement bore adequate indicia of reliability. But 2 decades ago, the court changed course to better reflect original understandings. In Crawford v. Washington, the court deemed it fundamentally at odds with the right of confrontation to admit statements based on judicial determinations of reliability. The clause, Crawford explained, commands not that evidence be reliable, but that reliability be assessed in a particular manner, by testing in the crucible of cross-examination. And so the clause bars the admission at trial of an absent witness's statements, however trustworthy a judge might think them, unless the witness is unavailable and the defendant had a prior chance to subject her to cross-examination. But not always. The clause's prohibition applies only to testimonial hearsay, and in that 2-word phrase are 2 limits. First, in speaking about witnesses or those who bear testimony, the clause confines itself to testimonial statements, a category whose contours we have variously described. Second, and more relevant here, the clause bars only the introduction of hearsay, meaning out-of-court statements offered to prove the truth of the matter asserted. When a statement is admitted for a reason unrelated to its truth, we have held, the clause's role in protecting the right of cross-examination is not implicated. That is because the need to test an absent witness ebbs when her truthfulness is not at issue. Not long after Crawford, the court made clear that the Confrontation Clause applies to forensic reports. In Melendez-Diaz v. Massachusetts, state prosecutors introduced certificates of analysis, essentially, affidavits, stating that lab tests had identified a substance seized from the defendant as cocaine. But the state did not call as witnesses the analysts who had conducted the tests and signed the certificates. We held that a straightforward application of Crawford showed a constitutional violation. The certificates were testimonial. They had an evidentiary purpose, identical to the one served had the analysts given live, in-court testimony, and the certificates were offered to prove the truth of what they asserted, that the seized powder was in fact cocaine. So the defendant had a right to cross-examine the lab analyst certifiers. In reaching that conclusion, we rejected the state's claim that the results of so-called neutral, scientific testing should be subject to a different rule. We again underscored that the Confrontation Clause commanded not reliability but one way of testing it, through cross-examination. And we thought that method might have plenty to do in cases involving forensic analysis. After all, lab tests are not uniquely immune from the risk of manipulation or mistake. The defendant might have used cross-examination to probe what tests the analyst performed, whether those tests presented a risk of error, and whether the analysts had the right skill set to interpret their results. 2 years later, the court relied on Melendez-Diaz to hold that a state could not introduce one lab analyst's written findings through the testimony of another. In Bullcoming v. New Mexico, an analyst tested the blood alcohol level of someone charged with drunk driving, and prepared a testimonial certification reporting that the level was higher than legal. But by the time the driver's trial began, that analyst had been placed on unpaid leave. So the state instead called a different analyst from the same lab to testify as to what the certification said. The substitute analyst had similar qualifications, and knew about the type of test performed. But the court held that insufficient to satisfy the Confrontation Clause. The surrogate testimony, the court explained, could not convey what the certifying analyst knew or observed about the particular test and testing process he employed. Nor could that testimony expose any lapses or lies on the certifying analyst's part, or offer any insight into whether his leave without pay was the result of misconduct. Concluded the court, when the state elected to introduce the certification, its author, and not any substitute, became the witness that the defendant had the right to confront. The very next term brought another case in which one lab analyst related what another had found, though this time on the way to stating her own conclusion. In Williams v. Illinois, state police sent vaginal swabs from a rape victim known as L.J. to a private lab for DNA testing. When the lab sent back a DNA profile, a state analyst checked it against the police department's database and found that it matched the profile of prior arrestee Sandy Williams. The state charged Williams with the rape, and he went to trial. The prosecution chose not to bring the private lab analyst to the stand. Instead, it called Sandra Lambedos, the state analyst who had searched the police database and found the DNA match. Lambedos had no first-hand knowledge of how the private lab had produced its results. She did not even know whether those results actually came from L.J.'s vaginal swabs, as opposed to some other sample. But she spoke repeatedly about comparing Williams' DNA to the DNA found in L.J.'s vaginal swabs. So in addition to describing how she discovered a match, Lambedos became the conduit for what a different analyst had reported, that a particular DNA profile came from L.J.'s vaginal swabs. Williams objected, at trial and later. He thought that, just as in Bullcoming, crucial evidence had been admitted through a surrogate expert, thus violating his right of confrontation. But the Illinois Supreme Court rejected Williams's claim, holding that Lambedos' testimony about the private lab analyst's finding did not raise a Confrontation Clause issue. The court explained that under state evidence law, an expert can disclose underlying facts and data for the purpose of explaining the basis for her opinion. And when she does so, the court held, the testimony is not subject to the Confrontation Clause because it is not admitted for the truth of the matter asserted. Thus, Lambedos could relay the private lab's finding that L.J.'s vaginal swabs produced a certain DNA profile in order to explain the basis for her opinion that there was a DNA match between Williams's blood sample and the semen sample recovered from L.J. The admission of the private lab report's contents for that limited purpose, the court reasoned, would aid the fact finder in assessing the value of Lambedos' opinion. This court granted Williams' petition for certiorari, but failed to produce a majority opinion. 4 members of the court approved the Illinois Supreme Court's approach to basis evidence, and agreed that Lambedos' recitation of the private lab's findings served the legitimate non-hearsay purpose of illuminating the expert's thought process. but the remaining 5 members rejected that view. Those 5 stated, in 2 opinions, that basis evidence is generally introduced for its truth, and was so introduced at Williams's trial. Justice Thomas explained that the purportedly limited reason for the basis testimony, to aid the fact finder in evaluating the expert's opinion, necessarily entailed an evaluation of whether that testimony was true. The validity of Lambedos's opinion ultimately turned on the truth of the private lab analyst's statements. A dissent for another 4 justices agreed. The utility of the private analyst's statement that Lambedos repeated logically depended on its truth, and the state could not avoid that conclusion by relying on Lambedos's status as an expert. Those shared views might have made for a happy majority, except that a different Confrontation Clause issue intruded. Justice Thomas thought that the private lab report was not testimonial because it lacked sufficient formality, so affirmed the Illinois Supreme Court on that alternative ground. The bottom line was that Williams lost, even though 5 members of this court rejected the state courts not for the truth reasoning. Our opinions in Williams have sown confusion in courts across the country about the Confrontation Clause's application to expert opinion testimony. Some courts have applied the Williams pluralities not for the truth reasoning to basis testimony, while others have adopted the opposed 5-justice view. This case emerged out of that muddle. Like Melendez-Diaz, this case involves drugs. In December 2019, Arizona law enforcement officers executed a search warrant on a property in the foothills of Yuma County. Inside a shed on the property, they found petitioner Jason Smith. They also found a large quantity of what appeared to be drugs and drug-related items. As a result, Smith was charged with possessing dangerous drugs, methamphetamine, for sale, possessing marijuana for sale, possessing narcotic drugs, cannabis, for sale, and possessing drug paraphernalia. He pleaded not guilty, and the case was set for trial. In preparation, the state sent items seized from the shed to a crime lab run by the Arizona Department of Public Safety, DPS, for a full scientific analysis. The state's request identified Smith as the individual associated with the substances, listed the charges against him, and noted that trial had been set. Analyst Elizabeth Rost communicated with prosecutors about exactly which items needed to be examined, and then ran the requested tests. Rost prepared a set of typed notes and a signed report, both on DPS letterhead, about the testing. The notes documented her lab work and results. They disclosed, for each of 8 items, a description of the item, the weight of the item and how the weight was measured, the tests she performed on the item, including whether she first ran a blank on the testing equipment, the results of those tests, and a conclusion about the item's identity. The signed report then distilled the notes into 2 pages of ultimate findings, denoted results/interpretations. After listing the 8 items, the report stated that 4 contained a usable quantity of methamphetamine, 3 contained a usable quantity of marijuana, and 1 contained a usable quantity of cannabis. The state originally planned for Rost to testify about those matters at Smith's trial. But with 3 weeks to go, the state called an audible, replacing Rost with a different DPS analyst as its expert witness. In the time between testing and trial, Rost had stopped working at the lab, for unexplained reasons, and the state chose not to rely on the now former employee as a witness. So the prosecutors filed an amendment to their final pre-trial conference statement striking out the name Elizabeth Rost and adding Gregory Longoni, forensic scientist, substitute expert. Longoni had no prior connection to the Smith case, and the state did not claim otherwise. Its amendment simply stated that Mr. Longoni will provide an independent opinion on the drug testing performed by Elizabeth Rost. And it continued, Ms. Rost will not be called. Mr. Longoni is expected to have the same conclusion. And he did come to the same conclusion, in reliance on Rost's records. Because he had not participated in the Smith case, Longoni prepared for trial by reviewing Rost's report and notes. And when Longoni took the stand, he referred to those materials and related what was in them, item by item by item. As to each, he described the specific scientific methods Rost had used to analyze the substance, for example, a microscopic examination, a chemical color test, a gas chromatograph/mass spectrometer test. And as to each, he stated that the testing had adhered to general principles of chemistry, as well as to the lab's policies and practices, so he noted, for example, that Rost had run a blank to confirm that testing equipment was not contaminated. After thus telling the jury what Rost's records conveyed about her testing of the items, Longoni offered an independent opinion of their identity. More specifically, the opinions he offered were, that item 26 was a usable quantity of marijuana, that items 20A and 20B were usable quantities of methamphetamine, and that item 28 was a usable quantity of cannabis. After Smith was convicted, he brought an appeal focusing on Longoni's testimony. In Smith's view, the state's use of a substitute expert who had not participated in any of the relevant testing violated his Confrontation Clause rights. The real witness against him, Smith urged, was Rost, through her written statements, but he had not had the opportunity to cross-examine her. The state disagreed. In its view, Longoni testified about his own independent opinions, even though making use of Rost's records. So Longoni was the only witness Smith had a right to confront. The Arizona Court of Appeals affirmed Smith's convictions, rejecting his Confrontation Clause challenge. It relied on Arizona precedent, similar to the Illinois Supreme Court's decision in Williams, stating that an expert may testify to the substance of a non-testifying expert's analysis, if such evidence forms the basis of the testifying expert's opinion. That is because, the Arizona courts have said, the underlying facts are then used only to show the basis of the in-court witness's opinion and not to prove their truth. On that view, the Court of Appeals held, Longoni could constitutionally present his independent expert opinions as based on his review of Rost's work. We granted certiorari to consider that reasoning, and we now reject it. Smith's confrontation claim can succeed only if Rost's statements came into evidence for their truth. As earlier explained, the clause applies solely to testimonial hearsay. And that means the clause does not bar the use of testimonial statements for purposes other than establishing the truth of the matter asserted. So a court analyzing a confrontation claim must identify the role that a given out-of-court statement, here, Rost's statements about her lab work, served at trial. On that much, indeed, the entire Williams court agreed. Amid all the fracturing the case produced, every justice defined its primary question in the same way, whether the absent analyst statements were introduced for their truth. The parties here likewise concur in that framing. If Rost's statements came in to establish the truth of what she said, then the clause's alarms begin to ring. But if her statements came in for another purpose, then those alarms fall quiet. Where the parties disagree, of course, is in answering that purpose question. Smith argues that the for the truth condition is satisfied here, just as much as in Melendez-Diaz or Bullcoming. In his view, Rost's statements were conveyed, via Longoni's testimony, to establish that what she said happened in the lab did in fact happen. Or put more specifically, those statements were conveyed to show that she used certain standard procedures to run certain tests, which enabled identification of the seized items. The state sees the matter differently. Echoing the Arizona Court of Appeals and the Illinois Supreme Court in Williams, the state argues that Rost's statements came into evidence not for their truth, but instead to show the basis of the in-court expert's independent opinion. And to defend that characterization, Arizona emphasizes that its Rule of Evidence 703, again, like Illinois', authorizes the admission of such statements only for that purpose, i.e., to help the jury to evaluate the opinion testimony. Evidentiary rules, though, do not control the inquiry into whether a statement is admitted for its truth. That inquiry, as just described, marks the scope of a federal constitutional right, and federal constitutional rights are not typically defined, expanded or contracted, by reference to non-constitutional bodies of law like evidence rules. The confrontation right is no different, as Crawford made clear. Where testimonial statements are involved, that court explained, the framers did not mean to leave the Sixth Amendment's protection to the vagaries of the rules of evidence. Justice Thomas reiterated the point in Williams, concepts central to the application of the Confrontation Clause are ultimately matters of federal constitutional law that are not dictated by state or federal evidentiary rules. We therefore do not accept a state's non-hearsay label at face value. Instead, we conduct an independent analysis of whether an out-of-court statement was admitted for its truth, and therefore may have compromised a defendant's right of confrontation. We did just that in Tennessee v. Street, and in so doing showcased how an out-of-court statement can come into evidence for a non-truth-related reason. Street was charged with murder, based mostly on a stationhouse confession. At trial, he claimed that the confession was coerced, and in a peculiar way, the sheriff, he said, had read aloud an accomplice's confession and forced him to repeat it. On rebuttal, the state introduced the other confession, through the sheriff's testimony, to demonstrate to the jury all the ways its content deviated from Street's. We upheld that use as non-hearsay. The other confession came in, we explained, not to prove the truth of the accomplice's assertions about how the murder happened, but only to disprove Street's claim about how the sheriff elicited his own confession. Or otherwise said, the point was to show, by highlighting the two confessions' differences, that Street's was not a coerced imitation. For that purpose, the truth of the accomplice's confession, and the credibility of the accomplice himself, was irrelevant. But truth is everything when it comes to the kind of basis testimony presented here. If an expert for the prosecution conveys an out-of-court statement in support of his opinion, and the statement supports that opinion only if true, then the statement has been offered for the truth of what it asserts. How could it be otherwise? The whole point of the prosecutors eliciting such a statement is to establish, because of the statement's truth, a basis for the jury to credit the testifying expert's opinion. Or said a bit differently, the truth of the basis testimony is what makes it useful to the prosecutor. That is what supplies the predicate for, and thus gives value to, the state expert's opinion. So there is no meaningful distinction between disclosing an out-of-court statement to explain the basis of an expert's opinion and disclosing that statement for its truth. A state may use only the former label, but in all respects the two purposes merge. Or to see the point another way, consider it from the fact-finder's perspective. In the view of the Arizona courts, an expert's conveyance of another analyst's report enables the fact-finder to determine whether the expert's opinion should be found credible. The jury cannot decide whether the expert's opinion is credible without evaluating the truth of the factual assertions on which it is based. If believed true, that basis evidence will lead the jury to credit the opinion. If believed false, it will do the opposite. But that very fact is what raises the Confrontation Clause problem. For the defendant has no opportunity to challenge the veracity of the out-of-court assertions that are doing much of the work. And if that explanation seems a bit abstract, then take this case as its almost too perfect illustration. Recall that Ross tested 8 seized items before she disappeared from the scene. At trial, the prosecutor asked the state's substitute expert Longoni to testify about 4 of them, with the rest dropping out of the case. A recap of their exchange about one item will be enough. The rest followed the same pattern. Remember as you read that Longoni, though familiar with the lab's general practices, had no personal knowledge about Rost's testing of the seized items. Rather, as his testimony makes clear, what he knew on that score came only from reviewing Rost's records. With that as background. Question. Turn your attention to item 26. I'm going to hand you what's been marked as State's Exhibit 98 Ross Notes. Did you review how item 26 was tested in this case? Answer. Yes. Question. When you reviewed it, did you notice whether the standard lab policies and practices that you have just described were followed? Answer. Yes. Question. Were they followed? Answer. Yes. Question. From your review of the lab notes in this case, can you tell me what scientific method was used to analyze item 26? Answer. Yes. Question. And what was used? Answer. The microscopic examination and the chemical color test. Question. That was done in this case? Answer. Yes, it was. Question. Was there a blank done to prevent contamination, make sure everything was clean? Answer. According to the notes, yes. Question. In reviewing what was done, your knowledge and training as a forensic scientist, your knowledge and experience with DPS's policies, practices, procedures, your knowledge of chemistry, the lab notes, the intake records, the chemicals used, the tests done, can you form an independent opinion on the identity of item 26? Answer. Yes. Question. What is that opinion? Answer. That is a usable quantity of marijuana. And then the prosecutor went on to items 20A, 20B, and 28. Asking similar questions, receiving similar answers based on Rost's records, and finally eliciting similar independent opinions, which were no more than what Rost herself had concluded. Yes, Longoni confirmed, just as item 26 was a usable quantity of marijuana, items 20A and 20B were usable quantities of methamphetamine and item 28 was a usable quantity of cannabis. Ross's statements thus came in for their truth, and no less because they were admitted to show the basis of Longoni's expert opinions. All those opinions were predicated on the truth of Rost's factual statements. Longoni could opine that the tested substances were marijuana, methamphetamine, and cannabis only because he accepted the truth of what Rost had reported about her work in the lab, that she had performed certain tests according to certain protocols and gotten certain results. Likewise, the jury could credit Longoni's opinions identifying the substances only because it too accepted the truth of what Rost reported about her lab work, as conveyed by Longoni. If Rost had lied about all those matters, Longoni's expert opinion would have counted for nothing, and the jury would have been in no position to convict. So the state's basis evidence, more precisely, the truth of the statements on which its expert relied, propped up its whole case. But the maker of those statements was not in the courtroom, and Smith could not ask her any questions. Approving that practice would make our decisions in Melendez-Diaz and Bull coming a dead letter, and allow for easy evasion of the Confrontation Clause. As earlier described, those two decisions applied Crawford in straightforward fashion to forensic evidence. The first prevented the introduction of a lab analyst's testimonial report sans lab analyst. The second refused to accede to the idea that any old analyst, i.e., a substitute who had not taken part in the lab work, would do. Arizona offers only a slight variation. On its view, a surrogate analyst can testify to all the same substance, that is, someone else's substance, as long as he bases an independent opinion on that material. And that is true even if, as here, the proffered opinion merely replicates, rather than somehow builds on, the testing analyst's conclusions. So every testimonial lab report could come into evidence through any trained surrogate, however remote from the case. and no defendant would have a right to cross-examine the testing analyst about what she did and how she did it and whether her results should be trusted. In short, Arizona wants to end run all we have held the Confrontation Clause to require. It cannot. Properly understood, the clause still allows forensic experts like Longoni to play a useful role in criminal trials, because Longoni worked in the same lab as Rost. He could testify from personal knowledge about how that lab typically functioned, the standards, practices, and procedures it used to test seized substances, as well as the way it maintained chains of custody. Or had he not been familiar with Rost's lab, he could have testified in general terms about forensic guidelines and techniques, perhaps explaining what it means for a lab to be accredited and what requirements accreditation imposes. Or as the Williams plurality and dissent both observed, he might have been asked, and could have answered, any number of hypothetical questions, taking the form of, if, or assuming some out-of-court statement were true, what would follow from it? The state of course would then have to separately prove the thing assumed. The United States, appearing as amicus curiae in support of neither party, usefully addressed these matters at oral argument, distinguishing Longoni's testimony as block quoted above from the various kinds of testimony just described. The latter forms of testimony allow forensic expertise to inform a criminal case without violating the defendant's right of confrontation. And we offer these merely as examples. There may be others. But as the United States acknowledged, the bulk of Longoni's testimony took no such permissible form. Here, the state used Longoni to relay what Rost wrote down about how she identified the seized substances. Longoni thus effectively became Rost's mouthpiece. He testified to the precautions, she said, she took, the standards, she said, she followed, the tests, she said, she performed, and the results, she said, she obtained. The state offered up that evidence so the jury would believe it, in other words, for its truth. So if the out-of-court statements were also testimonial, their admission violated the Confrontation Clause. Smith would then have had a right to confront the person who actually did the lab work, not a surrogate merely reading from her records. What remains is whether the out-of-court statements Longoni conveyed were testimonial. As earlier explained, that question is independent of everything said above. To implicate the Confrontation Clause, a statement must be hearsay, for the truth, and it must be testimonial, and those two issues are separate from each other. The latter, this court has stated, focuses on the primary purpose of the statement, and in particular on how it relates to a future criminal proceeding. A court must therefore identify the out-of-court statement introduced, and must determine, given all the relevant circumstances, the principal reason it was made. But that issue is not now fit for our resolution. The question presented in Smith's petition for certiorari did not ask whether Rost's out-of-court statements were testimonial. Instead, it took as a given that they were. That presentation reflected the Arizona Court of Appeals opinion. As described earlier, that court relied on the not-for-the-truth rationale we have just rejected. It did not decide whether Rost's statements were testimonial. Nor, to our knowledge, did the trial court ever take a stance on that issue. Because we are a court of review, not of first view, we will not be the pioneer court to decide the matter. And indeed, we are not sure if there remains a matter to decide. Smith argues that the state has forfeited the argument. Arizona, he says, gave no hint in the proceedings below that it believed Rost's statements were anything but testimonial. The state denies that assertion, pointing to a passage about Williams in its lower court briefing. The dispute is best addressed by a state court. So we return the testimonial issue, including the threshold forfeiture matter, to the Arizona Court of Appeals. But we offer a few thoughts, based on the arguments made here, about the questions the state court might usefully address if the testimonial issue remains live. First, the court will need to consider exactly which of Rost's statements are at issue. In this court, the parties disputed whether Longoni was reciting from Rost's notes alone, or from both her notes and final report. In Arizona's view, everything Longoni testified to came from Rost's notes, although he at times used the word report. A close comparison of the documents and his testimony reveals, the state says, that he meant only the notes. Smith disagrees, taking Longoni's references to the report, as well as the notes, at face value. According to Smith, Longoni relied on both documents and in fact treated them as a unit, with the notes attached to the report as essentially an appendix. Resolving the dispute might, or then again might not, affect the court's ultimate disposition of Smith's Confrontation Clause claim. We note only that before the court can decide the primary purpose of the out-of-court statements introduced at Smith's trial, it needs to determine exactly what those statements were. In then addressing the statement's primary purpose, why Rost created the report or notes, the court should consider the range of record-keeping activities that lab analysts engage in. After all, some records of lab analysts will not have an evidentiary purpose. The United States as amicus curiae notes, for example, that lab records may come into being primarily to comply with laboratory accreditation requirements or to facilitate internal review and quality control, or some analysts' notes may be written simply as reminders to self. In those cases, the record would not count as testimonial. To do so, the document's primary purpose must have a focus on court, and again, the state court on remand should make that assessment as to each record whose substance Longoni conveyed. Our holding today follows from all this court has held about the Confrontation Clause's application to forensic evidence. A state may not introduce the testimonial out-of-court statements of a forensic analyst at trial, unless she is unavailable and the defendant has had a prior chance to cross-examine her. Neither may the state introduce those statements through a surrogate analyst who did not participate in their creation. And nothing changes if the surrogate, as in this case, presents the out-of-court statements as the basis for his expert opinion. Those statements, as we have explained, come into evidence for their truth, because only if true can they provide a reason to credit the substitute expert. So a defendant has the right to cross-examine the person who made them. That means Arizona does not escape the Confrontation Clause just because Rost's records came in to explain the basis of Longoni's opinion. The Arizona Court of Appeals thought otherwise, and so we vacate its judgment. To address the additional issue of whether Rost's records were testimonial, including whether that issue was forfeited, we remand the case for further proceedings not inconsistent with this opinion. It is so ordered. Justice Thomas, concurring in part. I join the court in all but Part 3 of its opinion. The Sixth Amendment's Confrontation Clause provides, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. This clause bars the admission of an absent witness's testimonial statements for their truth, unless the witness is unavailable and the defendant previously had an opportunity to cross-examine that witness. Today, the court correctly concludes that when an expert conveys an absent analyst's statements in support of his opinion, and the statements provide that support only if true, then the statements come into evidence for their truth. But a question remains whether that analyst's statements were testimonial. I agree with the court that, because the courts below did not consider this question, we should remand for the Arizona Court of Appeals to answer it in the first instance. But I disagree with the court's suggestion that the Arizona Court of Appeals should answer that question by looking to each statement's primary purpose. I continue to adhere to my view that the Confrontation Clause is implicated by extrajudicial statements only insofar as they are contained in formalized testimonial materials, such as affidavits, depositions, prior testimony, or confessions. The Confrontation Clause guarantees a criminal defendant the right to be confronted with the witnesses against him. As I have previously explained, witnesses are those who bear testimony, and testimony is a solemn declaration or affirmation made for the purpose of establishing or proving some fact. This understanding is grounded in the history surrounding the right to confrontation, which was developed to target particular practices that occurred under the English bail and committal statutes passed during the reign of Queen Mary, namely, the civil law mode of criminal procedure, and particularly its use of ex parte examinations as evidence against the accused. Rather than attempt to divine a statement's primary purpose, I would look for whether the statement is similar in solemnity to the Marian examination practices that the Confrontation Clause was designed to prevent. In my view, the Arizona Court of Appeals should consider on remand whether the statements at issue have the requisite formality and solemnity to qualify as testimonial. If they do not, the Confrontation Clause poses no barrier to their admission. Justice Gorsuch, concurring in part. I am pleased to join the court's opinion holding that, when an expert presents another's statements as the basis for his own opinion, he is offering those statements for their truth. I cannot join, however, the court's discussion in Part 3 about when an absent analyst's statement might qualify as testimonial. As the court says, that issue is not now fit for our resolution. It was not part of the question presented for our review, nor was it the focus of the decision below. In fact, the state devoted so little attention to the testimonial issue in the Arizona courts that any argument it might make on the subject on remand may be forfeited. Further, the court's thoughts on the subject are in no way necessary to the resolution of today's dispute. What makes a statement testimonial, the court notes, is an entirely separate issue. Nor am I entirely sure about the guidance found in Part 3. The Sixth Amendment protects the accused's right to be confronted with the witnesses against him. As the court sees it, whether a statement being offered for its truth and tendency to inculpate a defendant triggers that right depends on the primary purpose of the statement, and in particular on how it relates to a future criminal proceeding. I cannot help but wonder whether that is correct. Just consider a few other possibilities. In protecting the right to confront witnesses, perhaps the Sixth Amendment reaches any person who gives or furnishes evidence. Or perhaps the amendment reaches all those who bear testimony. Perhaps, too, a statement bears testimony so long as it explicitly or implicitly relates a factual assertion or discloses information. To my mind, all these questions, and maybe others too, warrant careful exploration in a case that presents them and, without more assurance, I worry that the court's proposed primary purpose test may be a limitation of our own creation on the confrontation right. I am concerned, as well, about the confusion a primary purpose test may engender. Does it focus, for example, on the purposes an objective observer would assign to a challenge statement, the declarant's purposes in making it, the government's purposes in procuring it, or maybe still some other point of reference? Even after we figure out a statement's purposes, how do we pick the primary one out of the several a statement might serve? Or determine in exactly what way that purpose must relate to a future criminal proceeding? And if we fail to find some foothold in text and historical practice for resolving these questions, how can judges answer them without resort to their own notions of what would be best? Some time ago, Chief Justice Marshall charged the judiciary with being watchful of every inroad on the accused's right to be confronted with the witnesses against him. With that cautionary note in mind, I respectfully concur in all but Part 3 of the court's opinion. Justice Alito, with whom the Chief Justice joins, concurring in the judgment. Today, the court inflicts a needless, unwarranted, and crippling wound on modern evidence law. There was a time when expert witnesses were required to express their opinions as responses to hypothetical questions. But eventually, this highly artificial, awkward, confusing, and abuse-laden form of testimony earned virtually unanimous condemnation. More than a century ago, judges, evidence scholars, and legal reform associations began to recommend that courts abandon the required use of hypotheticals, and more than 50 years ago, the federal rules of evidence did so. Now, however, the court proclaims that a prosecution expert will frequently violate the Confrontation Clause when he testifies in strict compliance with the federal rules of evidence and similar modern state rules. Instead, the court suggests that such experts revert to the form that was buried a half-century ago. There is no good reason for this radical change. To explain why I think the court has gone far astray, I begin with a brief look at the history of expert testimony, and particularly, why the hypothetical question requirement was replaced by the superior, motive testimony allowed by the federal rules of evidence. Expert testimony presents a challenge for a legal system like ours that restricts a fact finder's ability to consider hearsay. This is so because an expert's opinion very often is based on facts that are not proved in court. As a modern treatise puts it, the value of experts lies in their ability to bring to bear a body of knowledge largely extraneous to the facts of the particular case. Wigmore made the same point when he wrote that no one professional man can know from personal observation more than a minute fraction of the data which he must every day treat as working truths. Instead, experts routinely rely on the reported data of fellow scientists, learned by perusing their reports in books and journals. Despite this problem, courts in Great Britain and this country long ago recognized the value of expert testimony and concluded that they must accept this kind of knowledge from scientific men, even if it meant allowing testimony based on facts of which the expert did not have first-hand knowledge. Recognizing this reality, a court in the late 18th century admitted expert testimony about the seaworthiness of a ship based on a survey conducted when the expert was not present. Similarly, an early 19th century decision allowed ship surveyors to testify to the seaworthiness of a vessel they had never seen. The opposing party objected that the experts did not know the underlying facts to be true, but the court admitted their opinions because the experts' technical knowledge could assist the jury. The fact that the truth of the facts stated to them was not certainly known went to the weight of the testimony, not its admissibility. Throughout the 19th and into the 20th century, experts generally testified in the form of an opinion in response to a hypothetical question. An attorney would ask an expert to assume that certain facts were true and would then query whether a particular conclusion could conceivably follow. This procedure was highly artificial because it bore little resemblance to the way in which experts actually form opinions, and the procedure surely did not conform to the way lay jurors think and speak. The procedure's aim was to prevent a jury from jumping to the conclusion that the facts packed into the hypothetical were true, but it is questionable whether the practice achieved that objective. For instance, here is the question that defense counsel asked a psychiatric witness in Charles Guiteau's trial for murdering President Garfield. Q. Assume it to be a fact that there was a strong hereditary taint of insanity in the blood of the prisoner at the bar. Also that at about the age of 35 years his mind was so much deranged that he was a fit subject to be sent an insane asylum. Also that at different times from that date during the next succeeding 5 years, he manifested such decided symptoms of insanity, without stimulation, that many different persons conversing with him and observing his conduct believed him to be insane. Also that during the month of June, 1881, at about the expiration of said term of 5 years, he honestly became dominated by the idea that he was inspired of God to remove by death the President of the United States. Also that he acted upon what he believed to be such inspiration, and what he believed to be in accordance with the divine will, in preparation for and in the accomplishment of such purpose. Also that he committed the act of shooting the President under what he believed to be a divine command which he was not at liberty to disobey, and which belief amounted to a conviction that controlled his conscience and overpowered his will as to that act, so that he could not resist the mental pressure upon him. Also that immediately after the shooting he appeared calm and as one relieved by the performance of a great duty. Also that there was no other adequate motive for the act than the conviction that he was executing the divine will for the good of his country. Assuming all these propositions to be true, state whether in your opinion the prisoner was sane or insane at the time of shooting President Garfield? A. Assuming those to be true, I should say the prisoner was insane. How likely is it that a jury hearing a question like that would keep in mind that all the facts loaded into the question were merely hypothetical and not necessarily supported by the evidence in the case? The Guiteau example illustrates many other problems with hypothetical questioning. For one, hypothetical questions were difficult for the attorneys to frame, for the court to rule on, and for the jury to understand. Like the question above, the hypotheticals were often so built up and contrived that they were impossible for either the jury or the expert to follow. One case involved a hypothetical that extended over 83 pages of typewritten transcript, and an objection involved in 14 pages more of the record. Such questions required an expert to have the extraordinary ability to comprehend in one mental operation the entirety of what has been asked so as to give any answer. And juries surely found following lengthy hypotheticals even more mystifying. For another, lawyers often used hypotheticals as a preview of their closing arguments. In doing so, they sometimes sneaked in irrelevant information and excluded necessary details. One medical expert declared that he had never known a hypothetical question, in a trial involving the mental condition of the defendant, which in his opinion offered a fair presentation of the case. As a result, experts either provided answers that were entirely disconnected from the actual case, or else they ignored the hypothetical altogether. Because opposing counsel often disagreed for strategic reasons about which facts should be included in a hypothetical, constructing a hypothetical that the judge would permit was often a tricky and contentious business. If counsel did not include enough facts to satisfy opposing counsel, the hypothetical would be met with an objection, and its sufficiency would provide grist for an appeal. The threat of dragging out litigation led counsel to make their hypotheticals even longer and more confusing. By the early 20th century, this form of testimony was scorned. In the second edition of his treatise, issued in 1923, Wigmore proclaimed the hypothetical question that feature which does most to disgust men of science with the law of evidence. Around the same time, Judge Learned Hand labeled hypotheticals the most horrific and grotesque when upon the fair face of justice. Professor Charles T. McCormick described hypotheticals as an obstruction to the administration of justice. Experts shared these concerns. One lamented that lawyers' use of hypothetical questions was often so unfair and confusing and degrading that it does not clarify the issue nor help achieve justice. Eventually, the use of hypothetical questions was nearly universally recognized as a practical disaster by lawyers, judges, and witnesses alike. This state of affairs sparked efforts to eliminate hypothetical questions as a requirement. Change began first in the courts, which allowed experts to sit through trial and then provide their opinion upon the evidence. More formalized rule changes soon followed. In 1937, the Commissioners on Uniform State Laws incorporated a provision in their Model Expert Testimony Act that permitted experts to give their opinions without preliminarily disclosing their underlying facts or data. In quick succession, both the Model Code of Evidence, issued by the American Law Institute in 1942, and the Uniform Rules of Evidence, approved by the American Bar Association in 1953, recommended abandonment of hypothetical questions. In 1972, the Federal Rules of Evidence followed suit with Rules 703 and 705, and many states made similar changes. What replaced hypotheticals was the procedure exemplified by the Federal Rules of Evidence. Rule 703 provides that an expert's opinion may be based on facts or data in the case that the expert has been made aware of or personally observed. And unless the court orders otherwise, Rule 705 permits the expert to state an opinion, and give the reasons for it, without first testifying to the underlying facts or data. These facts or data need not be admissible in evidence, and they are not admitted for the truth of what they assert. Instead, these facts or data may, under some circumstances, be disclosed to the jury for a limited purpose, to assist the jurors in judging the weight that should be given to the expert's opinion. However, this is not allowed unless the court determines that their probative value in helping the jury evaluate the expert's opinion substantially outweighs their prejudicial effect, and to prevent the jury from improperly relying on basis testimony for the truth of the matters it asserts. A judge must instruct the jury upon request to consider such evidence only to assess the quality of the expert's testimony, i.e., to determine whether an expert's statements are reliable. This procedure is sensitive to the risk of jurors mistakenly treating an expert's basis testimony as evidence of the truth of the facts or data upon which the expert relied. The rules provide important safeguards against this danger, such as the stringent probative value versus potential prejudice test and the requirement that a limiting instruction be given upon request. Plus, of course, an expert's lack of personal knowledge of the facts or data that are called to his attention can be brought out in cross-examination and stressed in a closing argument. This modern system is more honest because it reflects how experts actually form opinions. It is simpler and less likely to confuse, and it avoids many of the pitfalls of the old procedure. It may not be perfect, and evidence scholars have proposed a variety of reforms, but it is unquestionably better than the old regime it replaced. In light of the woeful history of expert testimony by hypotheticals, why has the court disinterred that procedural monstrosity? The court reasons that if an expert for the prosecution conveys an out-of-court statement in support of his opinion, and the statement supports that opinion only if true, then the statement has been offered for the truth of what it asserts. Or put differently, the truth of the basis testimony is what makes it useful to the prosecutor. That is what supplies the predicate for, and thus gives value to, the state expert's opinion. In other words, the court seems to think that all basis testimony is necessarily offered for its truth. This is just plain wrong. What makes basis evidence useful is the assistance it gives the fact finder in judging the weight that should be given to the expert's opinion. And a trial judge must, upon request, instruct the jury to consider it only for that purpose. If a judge rules that basis evidence is not admitted for its truth and so instructs the jury, where does the court discern a Confrontation Clause problem? The only possible explanation is that the court believes that juries are incapable of following such an instruction, but that conclusion is inconsistent with commonplace trial practice and with a whole string of our decisions. It is a routine matter for trial judges to instruct juries that evidence is admitted for only a limited purpose. This court acknowledged as much when it noted that there is no rule of evidence which provides that testimony admissible for one purpose and inadmissible for another purpose is thereby rendered inadmissible. Quite the contrary is the case. In such instances, courts use limiting instructions. And this court has repeatedly upheld that practice, even in situations with potentially life and death stakes for defendants and even with respect to statements that are some of the most compelling evidence of guilt available to a jury. These decisions credit jurors by refusing to assume that they are either too ignorant to comprehend, or were too unmindful of their duty to respect, instructions of the court. Indeed, we have described the assumption that juries will follow the instructions given them by the trial judge as crucial to the system of trial by jury. A brief survey of prior decisions shows how firmly this court has adhered to that practice. In one case, the court held that statements obtained from a defendant in violation of Miranda could be introduced to impeach that defendant's credibility, so long as the jury was instructed not to consider them as evidence of his guilt. In another, the court affirmed the use of evidence obtained in violation of the Fourth Amendment for impeachment when the trial court had carefully charged the jury that it could not be considered evidence of guilt. In a further case, the court upheld the admission of evidence of the defendant's prior criminal convictions for the purpose of sentence enhancement, provided that the jury was instructed that this evidence could not be used in determining guilt. In another decision, the court presumed that a jury could properly evaluate an eyewitness identification under the instructions of the trial judge. And in another, the court approved the admission of an accomplice's incriminating confession given the pointed instructions of the trial court not to consider the truthfulness of the confession in any way whatsoever. Most recently, we held that a limiting instruction was sufficient to defeat a Confrontation Clause claim. In that homicide case, evidence showed that a defendant had traveled with his co-defendant to commit a murder for hire. The trial court admitted the co-defendant's confession, which, as redacted, stated that he was in a van with some other person when that person shot the victim, but the court told the jury that the confession could be considered only for the purpose of determining whether the co-defendant himself was guilty. The defendant argued that admitting the confession even with a limiting instruction would inevitably prejudice him because other evidence and statements at trial enabled the jury to immediately infer that the other person described in the confession was him. Nevertheless, we presumed that the jury was able to follow the limiting instruction, and we therefore affirmed the conviction. Our cases have recognized only one situation in which a limiting instruction is insufficient, where a defendant is directly incriminated by the extrajudicial statements of a non-testifying co-defendant. We have declined to extend that exception, and the evidence in question in these cases is worlds away from an expert's basis testimony. If the court thinks otherwise, it needs to explain why basis testimony falls into this category and creates a greater risk of juror confusion than all the other situations in which the court has assumed that jurors are capable of following limiting instructions. The court's assault on modern evidence law is not only wrong-headed, it is totally unnecessary. Today's decision vacates the lower court's judgment because the testifying expert's testimony was hearsay. I agree with that bottom line, but not because of the majority's novel theory that basis testimony is always hearsay. Rather, I would vacate and remand because the expert's testimony is hearsay under any mainstream conception, including that of the federal rules of evidence. To understand why, begin with the facts. A state forensic scientist tested items seized from the defendant and concluded that they were marijuana and methamphetamine. The scientist took notes of her tests, and she signed a report confirming the results. At trial, she was unavailable, so the prosecution called another forensic scientist to provide his expert opinion about the testing, and he relied on the first scientist's report in doing so. Under the rules, he could have offered his expert opinion that, based on the information in the report and notes, the items contained marijuana or methamphetamine. In so answering, he would acknowledge that he relied on the report and lab notes to reach his opinion. He could have also disclosed the information in the report, if the court found that the probative value of that information substantially outweighed the risk of prejudice, but he could not testify that any of the information in the report was correct. For instance, that the first scientist actually performed the test she recorded or that she did so correctly. Nor could he testify that the items she tested were the ones seized from the defendant. He did not have personal knowledge of any of these facts, and it is unclear what reliable scientific methods could lead him to intuit their truth from the records. The strictures of the rules here track the requirements of our Confrontation Clause precedents. If he testified to the truth of the fact that the first scientist actually performed the tests indicated in her report and notes and that she carried out those tests properly, he violated the Confrontation Clause, assuming, of course, that the notes were testimonial, a question that the court does not reach. But he would also violate the rules, which do not allow experts to testify to the truth of inadmissible hearsay. In other words, except for the question whether the report was testimonial, the rules and the requirements of the Confrontation Clause are the same. This case thus offers no occasion to change the rules. As it happens, I agree with the court that Longoni stepped over the line and at times testified to the truth of the matter asserted. The prosecution asked Longoni on several occasions to describe the tests that Ross performed or to swear to their accuracy, and Longoni played along. He stated as fact that Ross followed the lab's typical intake process and that she complied with the policies and practices of the lab. He also testified that Ross used certain scientific methods to analyze the samples, such as performing certain tests or running a blank. By asserting these facts as true, Longoni effectively entered inadmissible hearsay into the record, thus implicating the Confrontation Clause. The court could have said that, and stopped there. For more than a half-century, the federal rules of evidence and similar state rules have reasonably allowed experts to disclose the information underlying their opinion. Because the court places this form of testimony in constitutional doubt in many cases, I concur only in the judgment. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.